In a unanimous ruling Wednesday, the Supreme Court ruled that the Constitution's ban on excessive fines does apply to states and local governments. The decision could limit the ability of police to seize property from criminal suspects. The practice is known as civil forfeiture. For some local jurisdictions, though, it is a big source of revenue. In this case, the court sided in favor of Tyson Tims of Indiana. Police seized his $40,000 Land Rover after he was arrested for selling $400 worth of heroin. In her opinion, Justice Ruth Bader Ginsburg said the Eighth Amendment's protection against excessive fines is, quote, fundamental to our scheme of ordered liberty and deeply rooted in this nation's history and tradition. Loyola Law School professor Jessica Levinson joins us now from Los Angeles to talk about this. Jessica, first, just walk us through how the court came to its decision.
Well, essentially, the question was, as you laid out, whether or not the Eighth Amendment and the prohibition against excessive fines applies to states and local governments. That's because, believe it or not, we haven't decided that the entirety of the Bill of Rights, which applies to the federal government, also applies to states and local governments. And in fact, even during oral arguments, I believe it was Justice Neil Gorsuch said something like, are we really still talking about the Bill of Rights here? And so what happened is we decided that, yes, the Eighth Amendment prohibition against excessive fines does apply to states and localities. And therefore, what's left unanswered is, what is an excessive fine?
Well, that's what I was trying to get to. Did you get a sense of how they might be able to kind of find the contours of what is an excessive fine? In this instance, the vehicle was, what, 4 times what the fine would have been. So is that kind of a measuring stick?
Well, what Justice Ginsburg says is it might be, and so expect an enormous amount of litigation over how much is too much. And the Supreme Court loves to use these kind of desperately unuseful phrases like it can't be grossly disproportionate. Now wait for years of litigation to determine what is grossly disproportionate. And as you said in the introduction, this is big business for states and local governments, particularly for law enforcement, for whom sometimes these civil forfeitures are up to 1/5 of their operating budget. So there's going to be enormous pressure on them to try and find a way to continue to seize property that wasn't necessarily used in a crime, but at least there's a suspicion that it was used in the commission of a crime.
Now, Justice Ginsburg also wrote that excessive fines played a dark role in American history. Tell us a bit more about what she was alluding to there.
So Justice Ginsburg, in I think a very crisp and efficient opinion, basically traced the history of excessive fines. And what she said is, in looking at post-slavery, the South in post-slavery era, there were so-called black codes and black laws, which essentially tried to keep the racial hierarchy by implementing excessive fines for things like vagrancy, essentially trying to criminalize quote-unquote normal conduct. And so what she acknowledged is there's a very dark history in our country of trying to use excessive fines against certain people. And certainly what we have here is a number of examples of, for instance, there was a grandmother who almost lost her house because people were selling heroin in her house. So she almost had a civil forfeiture fine of millions of dollars. So we have examples of this law being used really as a way to try and it's called policing by profit, and to try and get money for law enforcement and harm people who are accused of crimes, not necessarily even convicted of crimes.
So considering how valuable this policy is to a lot of the kind of state and local jurisdictions, how might Wednesday's decision impact future civil forfeiture cases?
Well, I think you're going to see a lot of tension between what the Supreme Court said today and what state and localities want to do. And I think that you're going to see a lot of litigation in the lower courts of kind of how much is too much. Is it 4 times the price of the crime? Does it matter if the crime is a violent crime? Does it matter if the crime is a white-collar crime, for instance? So I think you're going to see states, local governments, law enforcement kind of struggling with how do we determine when something is excessive? Do we look at the enormity of the crime? Do we look at the amount of money at issue? And of course, law enforcement has a deep incentive to try and keep funding itself and basically push the limit of what the Supreme Court will allow. This is very typical of what the court does. It has a kind of broad prescription, and then it says basically, lower courts, you sort it out. You tell us when it's too much.
Really interesting case, and we appreciate you giving us some of your insight into what it could all mean. Jessica Levinson, appreciate your time today.
Thank you.